I've been on the executor on a number of family members' estates over the years because of my background and because of the personal relationship with the family members. But recently I was appointed by the court to be the executor on a family member's estate. And the reason I was appointed was that the family members were going through the process of completing their wills and estate plan. They made a change to the will but had unexecuted wills. And this was your typical complicated situation where it was a blended marriage, second marriage with children from a previous relationship, owned businesses where they had different ownership levels between the husband and wife. And unfortunately, because they made a change to the will and then the husband passed away unfortunately quite suddenly, the wills were never executed, and the court's doing that they weren't the final will and therefore weren't put in place. So now you had a situation where someone's died intestate without a will, with family members that weren't necessarily part of the typical nuclear family, i.e. children from the previous relationship, and it had the potential to get quite messy. So because there was an interest in a superannuation fund and with life insurance, the spouse, it wasn't appropriate that they be the executor of the estate. So I was asked to step forward and take on that role, which I did. It's part of the family, it's something I would do willingly. That said, because it wasn't your typical estate, because it had a business interest, because it had a sibling from the previous relationship, it's been more complicated and messy than I thought. And the things that have jumped out to me in part of that role is that I've got a lot of technical knowledge. I've done this previously before. I do this as part of my day-to-day role. But if someone was stepping in without that, it would have been hard work and complicated. That said, it's still been very time-consuming. So it does eat up a lot of time when you're standing there as a third party and helping out these family members sort out some complicated situations. Combine that with, because there's now the issue with the child from a previous relationship and the intestate where they've got to split assets up that won't necessarily go according to what the client's wishes were or the family member's wishes were, nobody's going to be happy in the end. People are all going to be disappointed. And because of that, it means that me as the executor have had to take on more legal advice in each step that I do, rather than if I was the executor, I would have made those decisions because there would have been a clear path to follow according to the will or according to law. So unfortunately for the whole estate, that everybody's had to lawyer up, and if you've had 3 people or 4 people all obtaining legal advice about the same point, it becomes quite expensive. So the fund or the estate has paid substantially more in legal fees because unfortunately they hadn't signed one document. So the only ones that benefit are the lawyers. At the end of the day, it fractures family relationships. The estate's not distributed according to the wishes of the deceased. The lawyers get rich out of it, but nobody comes out better off because of it. It's unfortunate.